Hello, my name is Bashak, and today I'm going to be discussing the Whitting versus Rite Aid pharmacy case. A little bit of background on this case: it took place in Salt Lake City, Utah, and so for this particular case, the state law preempted the federal law. The plaintiffs involved in the case were Mrs. Susie Whitting on behalf of her husband, Mr. Theron Daniel Whitting, and the defendants were Rite Aid Pharmacy and Thrifty Holdings Incorporated. On to the case facts. Mrs. Susie Whitting allegedly calls the Rite Aid pharmacy to consult with a pharmacist for advice regarding her husband's consumption of Sudafed. Mrs. Whitting claims she discussed Mr. Whitting's history of prostate troubles and asked if it would be safe for him to take Sudafed with his known prior medical history. Mrs. Whitting claims Linda Smith, who was the pharmacist at Rite Aid at the time, approved Sudafed as safe for her husband to consume. Mrs. Whitting ultimately claimed Linda Smith's advice perpetuated Mr. Whitting's prostate troubles, causing him difficulty urinating, bladder distension, pain, and frequent hospital visits for nearly 2 years. Mr. Whitting then passed away later from an unrelated condition. Mrs. Whitting sued Rite Aid for malpractice, negligence, and res ipsa loquitur. Rite Aid Pharmacy filed a motion to dismiss this case. Rite Aid provided 2 counter-arguments for their case. They stated that the pharmacist's duty of care does not require giving adequate advice about non-prescription drugs, such as Sudafed, and also that the learned intermediary doctrine shields pharmacists from liability for failure to warn. Mrs. Whitting opposed Rite Aid's motion. For this particular case, in order for the motion to be approved, the issue that the court was looking at is whether or not a pharmacist is liable under the learned intermediary doctrine for failure to warn, in addition to the concept of negligence and whether or not it applies to non-prescription drugs such as Sudafed. Ultimately, the court decided that Rite Aid's motion for partial summary judgment to dismiss the case is denied. The reasoning and rationale behind their decision was that under Utah state law, pharmacists are not liable for over-the-counter drugs. Therefore, the learned intermediary doctrine does not apply. However, pharmacists do still hold a responsibility, and any advice given to patients is known as patient counseling. This means they can still be held accountable for negligence and malpractice as a reasonably prudent individual. The overall takeaways of this case was that this case really highlighted the difference between state and federal law in relation to medical products. Additionally, although the learned intermediary doctrine did not apply to this case, it did not take away from pharmacists' liability to adequately inform consumers when it came to giving patients advice. Ultimately, pharmacists should be informed and trained on patient counseling in order to avoid any issues such as this case in the future. Lastly, just to provide some clarification for the outcome of the case, I'm going to be briefly discussing some of the important terminology that I believe impacted the court's decision. The first term is res ipsa loquitur. This is a legal term that refers to when an act speaks for itself and it implies negligence just by the event occurrence alone. The next term is the learned intermediary doctrine. The learned intermediary doctrine states that physicians are responsible for educating the consumer about any side effects or relevant information about a drug upon prescription, which takes away any responsibility from the manufacturer or any outside third-party informants. A reasonably prudent individual is when an individual who has a responsibility uses common sense and their knowledge to determine whether an outcome was reasonable. Thank you so much for listening, and I hope I was able to shed some light on why Rite Aid's motion for partial summary judgment to dismiss the case in the Whitting versus Rite Aid case was denied.